Hey guys, how you doing? Welcome back to Fudbusters. I'm Matt LaRosiere, and we're going to talk today about the rare breed settlement, the rare breed and NAGR settlement that has been really making the rounds, and a lot of people are confused, and justifiably so. NAGR is saying this is a total victory. Anti-gunners are saying that Trump has legalized machine guns. I read the settlement, and I don't see any of that, though. In fact, reading the settlement at first left me with more questions than answers, and that's why I think it's really important that we talk about it here. To start off with, something just seemed a little bit off to me about this being the case, right? The first case for DOJ to announce a big settlement with. For two reasons, right? Both in the way it was going good for gun owners. In fact, we were on a pretty sure track to victory, it seemed. And also given the relative seriousness, right? The relative risk level of the different cases that are going on. In fact, like there's still cases of Biden era gun grabbing activity that have people sitting in prison right now, away from their families, right? And of course, Matt Hoover comes to mind. So that was one thing that just kind of stood out at me. So to start with, this all concerns the named parties, which being Rare Breed Triggers, Rare Breed Firearms, National Association for Gun Rights, Texas Gun Rights, and the 6 individuals. The factual recitals are just background information, including rah-rahing about the Second Amendment task force of the Trump administration, and states that upon review, that the government felt the FRT litigation was no longer in the public interest. Great. They do conveniently leave out the fact that they were already told to knock it off once in the pending litigation. But getting down to the terms page is where the meat and potatoes of this settlement really is. These are all of the terms, the different things that bind one side or the other, to the extent that this binds anyone at all, which again is going to be a topic for discussion as we round up. And again, as we start off with, they agree that within 7 days, they're all going to drop their lawsuits against each other. They're not going to proceed with seeking attorney's fees. And the government is agreeing to the extent practicable that it will return force reset triggers as it defines in the limited context that it is seized or taken as a result of a voluntary surrender. Such returns must be requested by individual owners by September 30th, 2025. And it's saying that it'll set up a website and stuff for people to do this. And of course, the government has already started waffling about how much it will already do this for. And I also want to point out, this is one of our first instances of weasel wording where I don't know if the words here are worth much more than the paper they're printed on. Practicable means able to be done or put into practice successfully. And that gives the government quite a bit of wiggle room to be like, whoops, lost it, or whoop, I don't know which one this was, or we got the serial numbers, or right. I'm not 100% sure on that one how much relief it actually grants. And again, we have already heard from somebody at NAGR that the government is taking the position that, oh no, we don't actually have to give them to everybody, just people who are parties to the lawsuit, which is again one of the things that we'll talk about, whether this has any effect at all. So in addition to that, it's returning all of the FRTs that it stole from Rare Breed itself, which is a lot, right? For Rare Breed, that's a really significant thing. That's a lot of money of business that was just completely tied up. And so that may have been significant in their decision. But that return is considered full settlement value of all of the lawsuits that Rare Breed has against the government. Yeah. And another caveat, the government is not returning any further force reset triggers that are evidence in criminal investigations, prosecutions, or civil forfeiture actions, which is odd because wasn't this whole thing supposed to be, right? Wasn't the whole result of this supposed to be getting the government to agree that these aren't machine guns? Isn't that what we were expecting would happen out of this? It kind of doesn't seem like that's quite what happened. So then we've got another section reiterating that this extinguishes all of the claims that Rare Breed, the named plaintiffs, and the gun groups have about anything arising out of the FRTs. And then we get down to paragraph 7 where it starts to get weird. Here in paragraph 7, Rare Breed and their head guys agree not to develop or design an FRT for use in any handgun, which the government here defines, or the agreement defines, as a firearm whose magazine loads into the trigger hand grip. That's weird, right? Especially because the National Firearms Act doesn't have a distinction between automatic weapons by barrel length. So I don't know if it just shines a light on the fact that this is something the feds are concerned with or not, but it really makes you wonder what the idea was here, right? What is the legal significance? What is the principal distinction that's being made? And frankly, I don't think there is one. They further agree, right, the Rare Breed guys, not to market, advertise, or encourage individuals to put FRT triggers on any handgun. Masterful wording. This handgun thing, this gives the government, or at least appears to give the government, the ability to control development of FRTs for handguns and possibly in other directions as well. And as we'll see later, DOJ is very clear about their stance on FRTs for handguns, and it appears to be that they think that they can make a differential determination that that's a machine gun, which would be very injurious to the law. It's not good. Anything that is a normal handgun, right? So your M11-9, MP9 Glock with a chassis, no go for FRTs, but I guess the C96 and Tech 9 are okay. And again, you may ask, what's the distinction? And the answer is that DOJ signed a paper, which they can back out of at any time, where they made it up. And they're going to pretend this distinction exists as long as Rare Breed and Co. agree to aggressively limit development of FRTs. And they steer clear of handguns. But how would they make this happen, right? Well, that's where paragraph 9 comes in, which smells a little weird, right? Paragraph 9 says that the Rare Breed and Company agrees to take all reasonable efforts to engage in patent enforcement seeking prohibitory injunctions against any person or entity that manufactures, sells, or distributes any FRT, right, as against how it was defined earlier, during the life of the 223 patent. So we've talked about the 223 patent before on the show, and if you want to have a good line-by-line analysis of that patent, claim by claim, you can definitely go check out that video. It's actually really interesting, and we'll be touching on the 223 patent more later on. That's the original one, for those of you who don't know, the very first, the one we all saw years ago when it first came out. So yeah, they must take all reasonable efforts to seek out these prohibitory injunctions. And it's specifically requiring that they seek out prohibitory injunctions, not just monetary damages. So it's specifically that they stop anyone else from making these, is what they're saying. And of course, this is at Rare Breed's expense. The United States will not bear litigation costs of any patent enforcement actions. And some people were saying, oh, so if they don't sue every single FRT or anything like an FRT, then the DOJ is going to back out of the deal and they're going to become a machine gun again. No, that's not the case, right? This is conditioned on the Rare Breed boys having a good faith belief that the subject of their litigation is covered by the 223 patent. But it's important to note a couple things here. One is that patent infringement extends to non-commercial, I just made it for myself types of uses. Patent infringement is make, use, sell, or import into the United States. All of those things are patent infringible. It doesn't matter. Sell is an independent one, right? So you're not going to be able to get out of this by saying, oh, well, I was just doing it for myself. That does not do that. And you could argue that if Rare Breed finds that you made one for yourself and they don't come squish you, that it could be interpreted as a breach of the settlement. So DOJ does wrap this later on in the document in terms of public safety, but it's pretty clear that this is bald-faced regulatory capture. This is basically DOJ maintaining control of the FRT while getting out of a losing lawsuit by hamstringing future development by means of a quasi-monopoly / partnership with Rarebreed, which is very awkward. And again, I'm just telling you how that looks. I wasn't in any of these backroom meetings, but that's how this looks to me. So again, moving on, Rarebreed's firearms may get their FFL back, which they lost earlier as a result of, unfortunately, the government's overzealous activities in this area. And then next up, we have another interesting one, a very interesting, very awkwardly worded paragraph 11, where the United States agrees not to enforce NFA's enabling provisions in the case of certain FRTs. Now, this is limited to FRTs that it describes as being at issue in NAGR v. Garland. Basically, that the trigger is forcibly reset every round, and attempting to override the reset will induce a malfunction, and that the FRT are not designed for use in and is used in handguns as defined above. At first blush, it's not readily apparent if this, the U.S. agreeing not to enforce the enabling provisions of the NFA against FRTs is limited to specifically, basically, the 223 patent, the Rarebreed FRTs, or whether it covers something like the super safety. When you look at the 5 criteria that the government put here on this agreement, which we'll talk about how enforceable it is in a minute, the sloppy wording of this section does not clearly and definitively state that any device meeting those criteria is good to go. And in fact, again, no one else is party to this. Additionally troubling here is that Rarebreed's patent enforcement company has taken the position that the super safety violates a patent that Rarebreed owns. Again, hold that thought. Go through, it exchanges mutual releases, right? Saying that the two hold each other harmless, and the claimants and government will be friends forever, and they're not going to fight over this ever again. Then paragraph 14 is another odd one, where the United States agrees to consider filing statements in support of Rarebreed's patent trolling, detailing the public interest to be served by these injunctions. Now, again, agrees to consider, right? So this covenant, this agreement has the legal significance of an ink blot, but it really smells bad. DOJ, their most likely interest here in taking this position is to curtail the widespread availability and further development of FRTs. And I think it thinks that it can prevent an FRT from a handgun from ever existing by behaving in this fashion. Paragraph 15 sees Rarebreed agreeing to promote the safe and responsible use of its devices. Yeah, nothing in this is intended to create rights enforceable by persons other than the named claimants as plaintiffs in the civil litigation. That's interesting. Nothing in this agreement is intended to create rights enforceable by persons other than named plaintiffs. Big win. Categorical victory, right? And then paragraph 17 explains that for some reason this agreement has nothing to do with the 2 civil cases that one of the Rarebreed owners has pending in Seminole County, where he is an attorney for someone named Lelou, involving slander and tortious interference, something to do with a Brazilian jiu-jitsu dojo or something. Is it just regular Floridian things that needed to be in this agreement with the DOJ? And again, the rest is, ordinary contract formalities, because that's what a settlement is. It's a contract. So I'm sure you're wondering, what does this actually do? Let's kind of look at that from the 2 different sides of the agreement. From the government's perspective, this means that they have a way to put an end to litigation that they were on the losing side of, and by doing it this way, they're preventing a circuit or possibly even nationwide result saying FRTs are good to go, right? Which would likely have been the case the way that Cargill went. So basically, the government still has the tool in the toolbox if it really wants to use it, and they get the carrot of curtailing the widespread adoption and development of more FRTs. Plus, the government seems to think it has a policy interest in preventing handguns from winding up with FRTs, again, that's not really legally or logically comprehensible distinction, aside from the fact that the government is probably just has a outsized concern with Glock switches, especially the way they show up in the media so much. As for what this does for the claimants, right? Just remember, the claimants were on the winning side, right? They were going to get probably more relief than this. So that's a really weird one, right? As to why they would sign this. It's pretty easy to see why the government would sign this. Again, remember, plaintiffs are doing awesome. Seem to be on track for a victory in the Fifth Circuit. And given the way the Supreme Court wrote Cargill, it looked like they were on the right side of the guardrails. Should it go all the way? So aside from snatching defeat from the jaws of victory, why do this? Well, on the one hand, it's a sure outcome. There's two clear winners here, and their names are DeMonico and Maxwell. From a business perspective, an injunction saying devices that work like this would be bad for their business. People would find a way to compete, and this settlement, if its words have more value than the paper they're printed on, would effectively give them a monopoly on the entire market, beyond that which their patents would seem to grant them, a sort of legal because we said so monopoly on top of the supposed intellectual property monopoly that they already have. But you heard me hint a few times now, is this actually enforceable? Does this actually do anything? In my opinion, no, it doesn't, on two different equally weird fronts. For one, the government cannot actually bind itself not to interpret the law a certain way. If the government could just write contracts in a civil lawsuit to get the result it wanted, the Administrative Procedures Act would be dead letter. You'd see environmental groups go to courtrooms even more than they do now, rather than lobbying to tweak the Clean Air Act. That's just not how it works. Imagine if Biden's ATF sandbagged with anti-gun groups to settle this interpretation and agree that pistol braces are and always will be forever and ever stock same men, for example, right? That would be the same thing. And it just doesn't work that way. Administrative agencies are charged with interpreting the law. You can't separate that to civil agreement, especially with any private entity. But they promised, right? They signed the agreement, you might say. Yes, they did. They promised not to ever do it again and to keep not doing it forever and ever, amen, unless it's a handgun. But what about when they do anyway? Well, the parties to the agreement could sue. They could say, hey, we had a contract, and they would be right. The government would have violated the terms of that contract. A contract with no remedies provision. So what are the damages? Damages would be very, very fun to try to calculate, right? Because then this government in that position that was wanting to go back on this deal would be saying, we're just trying to enforce the law the way it's properly written. The government's saying that, not me, right? And they're trying to stop us. What are the damages? And then the court would look to them, and you can guess which circuit this would be filed in, right? And say, what are your damages in getting to break the law? I don't think it would go very well for the claimants, right? And you're thinking, oh, but no, but if they sue, they could bring a sue in the good circuit, right? Okay, great. Remember when the anti-gun groups got together with a bunch of state attorneys general and sued to enjoin different settlements where they were actually somewhat enforceable? Why would they not do that here in the Ninth Circuit? Why would they not? They could do it at any time if it is ever brought up. So, but that's one side, right? What about the other way that this is worthless? Remember, much of this agreement focuses on Rare Breed's 223 patent. Now, Rare Breed, by this agreement, seemingly deputized by the Department of Justice, is to patent troll as hard as it can to prevent this technology from falling into the wrong handguns. So Rare Breed has already begun filing these, by the way. So, of course, that all depends on the 223 patent and how good it is. We talked about the 223 patent in detail, like I previously said. So basically, the Rare Breed patent, in so many words, covers the blocking bar elements of the force reset trigger. The main elements are the locking feature, how it forcibly resets the trigger, preventing the trigger from being pulled again till the firearm's in battery. And the context of the Rare Breed patent is a AR-15 type firearm, right? Fire control mechanism pocket, transversely aligned pairs of hammer and trigger pins, blah, blah, blah. There's the locking mechanism as it's timed with the bolt carrier. to knock you off of the trigger until it's safe to fire again and then allow you to pull it back again. That's the whole way it works. We've talked a lot about Graves' patent and this and that and the other thing. But what if something had all of these features 90 years ago, right? What if there was a patent that expired in the 1950s? Well, Ivan, this is actually pretty cool. Well, Ivan was doing some historical research to prove that Glocks aren't uniquely easy to convert into bullet hoses. You remember some of those lawsuits that came around. He found this patent when looking into the 1911 side of things. It's 2056975. We'll call it the 975 patent. It was invented by Mr. Charles J. Michal, and he first applied for it in March of 1934, and it covers machine gun and converter, therefore. Now, before you start saying, oh, the FRT is not a machine gun, take a step back, right? Mr. Michal patented the device 4 months before machine guns were regulated by the NFA at all. When Mr. Michal applied for this patent, and certainly when he was inventing it, a machine gun was still something you could order in a catalog to your house, right? It did not have a statutory definition. There was no single function of the trigger issue to worry about. So we look at the Michal patent, and we read through the claims. We find a lot of discussion about lock breech firearms, about the need for the firearm to have the trigger reset between each shot. And being that it's a much earlier firearm patent than the type we're used to now, its claims are much broader and cover a lot of ground. For example, I'd like to point out claims 7 and 9. So claim 9, the combination with a semi-automatic firearm in which the trigger must be released between successive shots of means articulated by the recoil of a recoiling part. Said means consisting of a converter operatively connecting said recoiling part with the trigger, whereby to force the release of the trigger against the tension in the trigger finger of the operator, and to permit this tension to pull the trigger upon the completion of counter recoil, whereby the firearm is rendered fully automatic. Again, this is a different idea of fully automatic, but what's being described there. Then claim 7, in an attachment for concerning a semi-automatic pistol, a pivoted element, a projection therefrom for engaging the side of a pistol, and a second projection from the pivoted element for engaging the trigger, whereby the trigger is moved into the pre-firing position against the pressure of the trigger finger of the operator and is held inoperative during recoil and counter recoil, and is instantly released for firing under continued pressure of the trigger finger of the operator upon the completion of counter recoil. So there's a lot of different elements, and it's all, again, very well summed up in this embodiment, which, as you can see, is functionally identical to the rare breed idea. You have this little arm that is number 17 in this image, which knocks the trigger forward, completely holds the trigger forward as long as the reciprocating mass is traveling, and only when it comes back into place are you able to pull the trigger again. This was not referenced in the 223 patent, likely because, again, the language was very different. It works in the exact same way the 223 patent functions. There's a locking member which imparts on the slide the functional equivalent of the bolt carrier, energy from which the forces the trigger to reset, the geometry of which prevents the trigger from being pulled again until the slide goes back into battery, which is the functional equivalent of the bolt carrier. Now, of course, there are some pieces of nuance here. To invalidate a patent with prior art, there's two ways of doing it. One is through anticipation, which basically says the old patent anticipated your entire invention, and you can find it from the claims of the patent. These claims are very broad. The other, more common way is obviousness, which is that this old patent combined with some other patents render this patent obvious and thus not novel and not eligible for patent protection. Respectfully, I believe the 975 patent either anticipates or, I think much more strongly, renders obvious the 223 patent. I think the only argument against anticipation, where the new patent would be just outright invalid, that I see are a structural distinction between the slide and bolt carrier. However, I think that's a weak argument. I think the bolt carrier and slide are both structurally and functionally interchangeable. Plus, Michel's disclosures are much more broad, and I do expect that they anticipate the rare breed, because the rare breed use case is the only separation is the word bolt carrier and then the discussion of transverse pins, but I don't think those pins make anything different. So perhaps when you combine it with a previous patent for a AR trigger cassette, That's it, and it's rendered obvious. Now, in a challenge to the rare breed patents on obviousness grounds, I think the 975 patent, covered with other patents that previously disclosed AR drop-in cassette triggers, coupled with the Stoner patent, which invokes bolt carrier timing, presents a strong case to invalidate the 223 patent. Now, again, I don't think the FRT is a machine gun under the law. I also don't think Mr. Michal's is either, because it works in the exact same way that the FRT does. The term simply hadn't been given a definition at the federal level back when Michal made his device, right? And the technical precision we ascribe to machines today didn't exist at that time either. What I do think is that this settlement was not a win for us. I think most people anticipated a solid win on the case in the Fifth Circuit, which would have had binding precedent that would have been helpful for us all. With this agreement, that's all gone. There's no binding precedent. The only thing you've got is the district court orders and a pinky promise agreement that has no consequences if either side decides to wander off. It's an overall nothing burger. To be fair, I really like the guys at NAGR, and I think they did an amazing job. I think their briefing in this case was fantastic. I don't expect this result was their choice. I feel like this may have been the result of some external pressure, but the fact that they're touting this as some kind of big win or totally victory is frankly embarrassing. In my opinion, the parties in this case snatched defeat from the jaws of victory in an attempt to personally enrich two guys, and that makes me sad. And I think it's really embarrassing that they're calling this a win and doing victory laps with it. They lost. We lost. But that's my take. You're free to disagree. And again, I appreciate you guys watching and supporting. It's been amazing having all of my patrons that we've gotten to talk to every day, me and Ivan in the Discord. Please come join us. Twig is late this week because Ivan is a little sick and we've got a lot going on, but we will be back with a vengeance. I hope you enjoyed a little traditional Fudbusters upload. And again, we're working constantly to get back into the swing. If you want to support my content and also support my legal work, you can consider joining the Patreon. There's all kinds of benefits. But again, that's my take, guys. My opinion in a quarter might be able to get you a gumball some places, but I figured I would put it out there. That's it for today, guys. See you next time.